Hello, my friends. We're back for the afternoon session of day 5 of the Ashley Benefield trial. I tried to take a little quick break and go get myself a refill, maybe a little snack, and all of a sudden there's all this stuff going on in the chat. So I'm just back to say that I back my mods 100%. So if people start attacking my mods, we're going to have trouble. They work really, really hard to make this a safe place for everybody. So I don't really know what happened. Jules is here. She's backstage, but I will tell you that I'm going to back my mods 100%. And what you need to understand is that when there's 5,000 people in the chat and the chat is moving crazy like a mile a minute, sometimes people are going to get timed out by accident because the chat's moving quickly. If a mod is on his or her phone, they may time you out by mistake. You can't attack them. You can't go crazy on them. I'm not going to tolerate it. So let's everybody be nice. It's like I shouldn't have to be a high school principal. Look, here. Be nice or leave. That's it. I don't know that I don't need the drama. I have teenagers. I don't need the drama. Here's Jules. She's been in the courtroom. It's been very cold today. She's with us with a camera today. Hi, Jules.
Hi, how are you? That's because I figured out how to do the StreamYard thing. What's difficult?
Yay.
Yeah, so there you have it. I might
so
forget it by tomorrow, but you got it today.
Awesome. Tell us what's happening today. You look cold in there. Somebody sent me a Venmo. A really amazing viewer said, please send this to Jules to get some fingerless gloves because she looks really cold in the courtroom.
It is absolutely freezing in that place, and you can't get away from it. There's no place that you could sit anywhere in that courtroom that is going to make it comfortable. It's just freezing. But I sit where I sit. This is for all my haters out there. I sit where I sit so I can view the jury. I'm not watching the witness because I can, I know how to multitask. So I could listen to what the witness is saying, but my eyes are on the jury because that's what's more important to me is jury reaction.
How's the volume in the courthouse? Can you hear the witness okay?
Oh, yeah. Yeah, you
Oh,
could hear
good.
I could hear the witness perfectly fine. Mr. Taylor is a bit difficult. He seems to be soft spoken, and he stands a few feet away from the microphone. So, but we could hear him. It would be nice though if he was a little louder.
He said he was under the weather today, and also the judge too.
Yes, and FYI, it started out with only those two, but as the morning progressed, you started hearing more and more coughing in the gallery. So something is going on, and I just got over COVID, so I'm a little nervous. Yeah.
Hopefully you
So
won't get it again because you just had it.
yeah, I
That's the
just
only
had.
benefit.
Yeah, July 2nd is when I was diagnosed with COVID. So
Oh, that's terrible.
I know.
Terrible. All right, so tell us, what's the vibe today? What are you seeing? What are you looking
The
to
vibe
what
is on the prosecution side, Tom Benefield, Eva, Tom's wife, like first off, that side of the courtroom is packed. They had a lot of people that showed for them today. I don't know how many are, actual family members versus friends, but they've got a large group. They're all very upbeat. Um, I see a distinct change in their personality from Friday today. So they're very, very upbeat, and the same goes on Ashley's side. Uh, More people showed up today. However, I see a more subdued. They seem more subdued today than they have,
you mean the
any other
people that
day.
are supporting Ashley in the courtroom? How are they reacting to the defense's case and note-taking the jury now?
Again, this jury is so hard to read, but during Bruce Ferris's testimony, they were paying very close attention to him, but at that point, there was really no note taking. The only people that were taking notes was Eva Benefield a person sitting next to her and her uncle who was behind her. So there was at one point, though, during testimony when he verified that abusers abuse family pets, especially
Mhm.
when those pets belong to the victim and that they're missing empathy. One female juror did start writing. So
Mm.
so that was, that was good, but they were paying close attention. That was the only time I saw a juror uh, take notes. Then during cross examination, um, uh, one juror, this was a different one, this is the juror that was sitting next to the one that started taking notes,
Mhm.
was nodding their head up and down during the testimony in regards to being isolated. Um, I'm sorry, that was not during cross, that was during direct. So it was a different juror from taking the notes that was nodding her head up and down, almost, in my opinion, I'm not a body language expert, but in my
Mhm.
opinion, agreeing with, the term isolation and such. But when cross examination took place, no note taking except one female juror, a different one. She took notes and she was nodding her head up and down in agreement with the state. So
Hmm.
his Bruce Ferris's testimony, I think, um, it could go either way. That's
Yeah.
my opinion.
I mean, it was great that they got him in and that he was allowed to testify. I thought that was great. What about, okay, so the next witness after Bruce Ferris, the DV expert, was the woman who worked for Stephanie Murphy, who came in to talk about the um the restraining order.
Yeah,
How was that received?
and no notes. They were looking at her. Um, no disrespect, but I'm not quite sure that they understand where Mr. Taylor was going with this.
Mm-hmm.
I picked up on it right away. My, I'm not quite sure they did, and the only reason why I'm saying that is because they don't take notes. So it's like I don't know what's going on in. I can't tell because if I saw somebody pick up a pen and start writing, with the discrepancy of the dates of what Stephanie Murphy testified to as
Mm-hmm.
opposed to what she did, that would give me an indication that they picked up on it. So I don't know, Melanie. It's a hard read.
Yeah. So she, I think, came in to testify that she sent Gillum that restraining order and that he said,
Yeah.
oh, yeah, it was never entered or whatever. He thought it had expired already. Then the most interesting testimony that I thought of the day was the realtor. I found that to be shocking.
Me too. And boy, oh boy, did the state fight its hardest not to get that in. Not to get it in. So, with all the sidebars that took place, I mean, he was able to point it out on the map showing that that's the house he wanted, and but he was not allowed to say that the house directly behind it was where Ashley was, but he was able to get Sands's name out there as being the house next to that one.
Right.
um
But he got the address out and they've been told at the address that Ashley lived at with her mom. So connect the dots on that one. Not too hard, right?
right, but like I said, they're not avid note takers, so you know
But here's the
um
difference in Florida. They can ask for readbacks and they'll get them, right?
yeah, yeah,
Massachusetts in
so
the Karen Reed case, I don't know if you followed that, but they had the
yeah,
jurors were allowed to take notes, but no readbacks. So they
yeah,
couldn't say, "Can you read us back the realtor's testimony?"
yeah,
So that's the difference here. Like they don't have to rely on their notes. In Massachusetts, they had to rely on their notes. There was nothing else that they could get. So that
yeah.
doesn't bother me so much, I gotta say, to be honest. A lot of them have good
Okay.
memories. It's not this is only day 5, right? Karen Reed was like up to something like 70 something witnesses. So I think
And the defense is going to rest today.
Yes, that's what they said, right? He said, I think so. They have 4 more
There's
witnesses
only
this
four.
afternoon.
Four. Yeah, four.
If you're just tuning in for the afternoon stream, this is Jules. Jules is a court watcher. She's sitting right behind Ashley in the gallery. She's looking cold. So I'm going to send you that kind Venmo for some fingerless gloves for yourself. Thank you to, I want to thank whoever sent it. And also the testimony regarding the realtor. So a realtor came in and testified that he was contacted by Doug Benefield in March of 2018, and he wanted to buy the house directly behind the house that Ashley was living in with her mother. And that was during the time that the restraining order from South Carolina was still valid. So I
Yes.
found that to be incredibly important testimony. What I did not hear them say is whether or not Ashley knew about that. Did you notice
No.
that?
Yeah, I noticed it, and I wondered why, unless it was considered hearsay and the judge wasn't going to let it in. I don't know, but no, that did not come out.
But it was all testified to in front of the jury, so they were there. Susan Waters is sending you a pair of gloves, so thank you to Susan Waters.
Thank
Um,
you. The trial
so
will be over by that time.
I know.
This is good.
I'll Venmo
Definitely.
it. I'll Venmo it to you today.
This is gonna go to the. I'm gonna say the jury's gonna get this Wednesday.
You think so? Well, tomorrow.
Yeah,
I think they may
I
get it
don't think
tomorrow.
rebuttal is gonna definitely start in the morning. I don't think the state has that many witnesses on their list. So I would, but I don't know if it's going to be quick enough that they're going to be able to do closings tomorrow. So I'm going to say closings is going to be Wednesday morning and jury's going to get it in the afternoon.
All right, we'll see what happens.
We'll
Well,
see.
this judge likes to move things along, so I don't know.
Yeah.
Yeah, people are saying, yeah, he wanted to buy it, then he wanted to rent it. Regardless, whether she knew or not, it goes to his state of mind and to his wanting to watch her all the time and his willingness to violate a restraining order.
Yeah.
So I haven't heard anybody get on the stand to say Doug Benefield was a really great guy.
Except Tommy.
Well, Tommy, who didn't even know who Ashley was 8 months after they got married, when he went to town, he was like, "Who's Ashley?"
Yeah. Right.
We don't know, Olyanka, how they found out. I'm assuming it was during Doug's phone extraction. That's where those emails came from. That's what I'm assuming. Um, you guys are flying by. Tell us about Eva Benefield today. We've seen her go in and out of the courtroom a couple times.
Yeah. Hi. That was the deputy from court. He buys
I
his
think
lunch here. He buys his lunch. Everybody comes to this deli.
is it the only game in town for lunch?
Well, it's the only one that is quick within walking distance. It's literally 2 streets over.
Hmm.
No, three over. It's the only one within walking distance. If not, you got to get in your car and drive. And because of time constraints, I'm not getting in my car and driving because
Right.
with traffic as no. Anyway, um, I did see her get up several times, but I don't recall during what part of the testimony it was. But she was in and out. Tommy was in and out as once or twice as well. But again, she was. I just want you to all know, don't hate on me, please. But the Benefield family were very nice to me this morning. So
Oh,
they
that's
were,
nice. Listen,
yeah,
everybody should be nice.
yeah,
It's terrible they lost a family member. And Eva, I breaks my
absolutely.
heart. She lost both her parents.
Yes.
And
So, but I've been accused of taking sides. I'm not taking sides. I am just reporting my observations,
Mhm.
what I hear and see in the courtroom. But he actually went out of his way to say good morning to me. Um, and the rest of the family smiled and nodded towards me, as well as Ashley's family. Uh, I did find out, I did get an answer to your question from last week about certain individuals that are sitting in the courtroom that knows things. And I did ask on Friday why they weren't being called as witnesses, and I was told that they were told that what they have to say would be considered hearsay.
Oh, I don't remember who we were talking about
The lady in
specific.
lavender
Okay, right. Her friend, right? Yeah.
and the man bun.
Oh, yeah. So where's Ashley's mom?
They,
Outside the courthouse? She's not allowed to sit in, right? Because she's maybe
she's
called on
not.
rebuttal.
Yeah, she's not allowed to be called in. That's craziness.
It's sad that she,
Uh,
can't really be there to support
yeah, and
us.
she there was only one person out in front of the courthouse this morning when I got here holding a sign. You know,
Really?
yeah, it was not her mom nor her daughter. It was somebody that I never saw before. So
Oh, okay. So there's less support out there than there was at the beginning of the trial or even during jury selection.
yeah.
What about how did they receive Dr. Quintal's testimony?
Interesting that you should bring that up. Um, Two of the female jurors did take notes during both his direct and his cross examination. Um, what I found particularly interesting, which I wrote down, was that he was able to get in there, which I was surprised, but he said that Doug presented as domineering and controlling, and you know, the state really tried hard for that not to be introduced, but he was able to get that in there. And also, this part I'm not quite sure I agree with, but this was his testimony. Um, he said because Doug was physically fit and well built, equated him to being an alpha male. I'm
Yeah.
I'm not quite sure I agree with that.
It depends on your definition of an alpha male, which they didn't go into. And I wanted them to say, okay, what's your definition of an alpha male?
We
Right?
didn't get that, but we didn't
Right.
get that.
But he
And
also got in there that he told the detective that Doug said, I'm not going to let her get away from me, which jives with her story of being cornered in the room and him not letting her leave and her saying she was afraid for her life because he said, you're effing done. After she explained, like, listen, I don't want us to, like, we're never going to be back together, or we are never, ever, ever getting back together, as Taylor Swift would say. And then I'm never going to let her get away from me.
do you think the day this happened that he may have been talking about the move to Maryland and she took that opportunity to say you're not moving in with us, and that's what caused.
Well, I think she testified to that, didn't she? Because he said, you need to start acting like a wife. You can't tell me that we can't live together. You know,
But
the
she didn't
experts have,
say, unless I missed it, she didn't say that it was at that time she informed him he was not moving in with them.
I have to go back and listen to it again.
Yeah,
But I think she
I
said
don't
she was a little bit um non-responsive maybe. And when she
maybe.
tried to tell him how to put the boxes in, she's like, yeah, because I want my stuff coming out first. And then, yeah, a lot of people say they think that's what happened and it escalated.
Well, Tom Benefield was. I couldn't see Eva, but I could see Tom. He was visibly upset during this testimony, and I could tell that he took great issue with what Dr. Cantrell was saying, especially when he got to the godly equals over the top, not genuine. When the prosecutor uh, uh, objected before this was coming out, he was like nodding his head like he was happy that she objected. But when the judge overruled it, he went just like this, like he didn't think that the judge was going to overrule the objection. So
Who are you talking about, Tommy?
yeah,
Mm-hmm.
And so uh, so they were able to me, in my opinion, I don't know if you took it this way, but uh, him saying godly equaled he was over the top and it really wasn't genuine,
Mm-hmm.
tells me that those Bible verses he would send her every morning was just another manipulation on his part.
Mm-hmm. A lot of
Think
people
that?
found that. A lot of people in the chat thought that when that day when he was sending all those messages, that it was like his way of controlling her. And, a lot of them had to do with servitude, bond servant, seeing himself as godly. And that, yeah, Dr. Quintal said he thought that Doug was over the top with all of that stuff. And that, in fact,
And
Ashley said she was scared of Doug.
yes, yes, and he also stated that he didn't think Doug was genuine.
Hmm.
So
And that
so
Doug was hell bent on them being together.
hmm yeah,
And that interesting incident where he said that Doug was sitting in the lobby for an hour and Emerson was out in the car and he never went out to say hello to her, which was interesting because a lot of people have been pointing out in all of his messages, he never asks about his daughter.
it's
It's
always
all about
Ashley.
Ashley.
Yeah, yeah. So it is what it is. But I'm taking. I have not taken a position on this. I'm still waiting. I'm waiting on rebuttal. Um, I I don't know. I don't know what she's going to come back with as far as rebuttal. I think that, in my opinion, the state did not prove their case beyond a reasonable doubt. Did they prove there may have been some shadiness going on between the two of them, or by both of them? Yeah. But did they prove beyond a reasonable doubt that she did this and she did this because of that evaluation? And yeah, it wasn't there for me. Has the defense thus far, up until today, put on a good defense? I think they have. There's some testimony, and I blame this on Taylor for not being able to execute certain questions more clearly that may have got lost in the shuffle. But for the most case, for the defense, for what they're presenting in the defense, I think he's done an okay job.
I think he's done a phenomenal job. Listen, when you claim stand your ground law as a defense or self-defense, the burden shifts to the prosecution. Prosecution's burden is to prove beyond a reasonable doubt that it was not self-defense. And I don't
Right.
think they've done that here. They have not called one witness to say Doug was the most gentle man you'd ever want to meet. He would never hurt a fly. He did not punch the dog. He did not throw the cat down the stairs. That's not true. He didn't fire the gun into the ceiling. Basically, what they've said is grilling Ashley on the stand. Well, he asked you to stop, didn't he? Didn't he ask you to stop arguing? And you didn't, right? You didn't stop. You kept arguing. You kept arguing. You kept that.
Blame the
Like
victim.
that could really turn the jury off, in my opinion.
Well, as far as what happened on Friday, truth be told, I had gotten up and gone to the restroom. And who was in the restroom but Eva Benefield?
Mm.
Um, but she had left the restroom before I did. When I left the restroom, as I'm coming down the hall, I heard wails. And what is
Oh, like
that?
crying?
Like, I'm telling you, like whales,
Oh,
and I didn't know where it was coming from. And as I started getting closer to the courtroom, it was getting louder. And Eva was on a bench to the left on her phone, didn't seem to be phased by it at all. But I'm like, what? And then once I got to the courtroom, I realized it was coming from inside the courtroom. By the time I got in there, the jury was gone. She was, um, you know, her head was down. I had no earthly idea what took place. Everybody on her side of the courtroom was visibly shaken, men and women alike. All of them were in tears, and I said, "What happened?" And even Brother Clark got sharp with me, and he's like, "Just sit down." And I was like, "Okay."
Oh, the
I
pastor?
Yeah, yeah,
Got
but he was crying, and I was, so
what point was
I
this? At what point during the day? That's today?
no Friday on
Oh,
Friday
Friday.
after what the prosecutor did to her. I
Oh, when
wasn't.
Ashley was crying. Okay.
Yeah,
Got it.
so
I'm thinking today. I'm like, what happened
no,
today?
no, no,
Okay,
no,
sorry.
no, no. Yeah, Friday. I just wanted you to be aware that I was not in there when that happened.
Right.
So I had to watch the stream back after court to find out to see what happened, because I wasn't in there. All I know is she was hysterical. I can tell you this: the streaks. I don't know if people saw it on wherever they're viewing from, but I saw real tears. I saw the stuff coming from her
Right.
nose. She was truly uh, shaken, and she was trembling. That's the one thing I was in there for during the first break, when they had asked, did she need time to compose herself, and she stood up
Mhm.
before the jury. From her head to her feet, because where I sit, I have a great view. She was trembling so bad that her pants were like willowing in the wind. That's how bad she was trembling. And then, like I said, I stepped out during cross, and I had no idea that the prosecutor made her step off the stand. And to me, I asked a few people, but people were more, instead of looking at because the ones I asked were there for her, and they weren't focused on the jury, they were focused on her. So, only one person, and that was Man Bun, who noticed the jury, and he told me that some of the women were just shaking their head. So, she I wasn't in there, so I can't give a clean assessment.
So
uh,
you
uh,
weren't in there for the reenactment. Oh my gosh, you missed the most
no.
horrifying thing of the day.
Yeah.
Wow, you can't
So
fake that, a lot of people are saying in the comment.
no, you
But you're saying that people on the, let's say, Benefield side of the courtroom, Eva's side of the courtroom, they were crying too?
no, no.
Oh, just
um
okay, just Ashley's side.
just on Ashley's side.
Ugh.
But in any case, Ms. Little, I have
Thank
to
you.
bid, I have to bid you goodbye and get back to court. Um,
Adieu.
have a nice afternoon, everyone.
Thanks
Make
for
sure you
coming in,
make sure you
Jules.
hit that thumbs up for Melanie.
Thank you. Thanks
All
so
right.
much, Jules. Love you. Take
Any,
care.
I'll talk to you
Bye.
tomorrow. Bye bye.
Bye. Okay, people were asking how I know Jules. I met Jules during the Maya Kowalski trial, which I covered extensively on my channel, which was another case out of Florida. It was a civil case, very tragic case. Kowalski versus Johns Hopkins All Children's Hospital. Many of you may know me from that case. And Jules was in the courtroom every day there too. She's a TikToker. I'm going to link her TikTok below because she didn't know her exact handle. And she covers a lot of these cases on TikTok. And oops. And that's how we met, because she would call in to other streams. I was not doing live trial coverage, I was doing recaps. And so when I was watching the live streams during the day on Recovery Addict, she would call in there and give her observations. Justice Jane says she never mentioned he abused her in her evaluation. Well, she mentioned his behavior, his text messages, his stalking, I mean, I don't know, are you saying physical abuse? Because she did admit on the stand that he never touched her until the day of the shooting. So if you're not considering any of his other behaviors abuse, and you're only talking about physical abuse, she did talk about him punching the dog in the face, throwing the cat down the stairs, shooting the gun into the ceiling, throwing a loaded gun at her, punching holes in walls. So I'm not really sure what your definition of abuse is, but again, that's the way people on other channels are trying to explain this away. Like, that was the first time he ever laid hands on her, and therefore she shouldn't have been afraid and shouldn't be able to use deadly force. And that's what the jury's going to have to decide. Thank you, Blue Mondays, for becoming a new member. Welcome, welcome. Maggie May Matt says, everything I saw reported pretrial in this case made me think she was guilty. I 100% see her as a victim now. I guess maybe the tide is shifting in some people's minds. Thank you. Susan Costello gifted 5 memberships. Thank you so much, Susan. It's awfully, awfully sweet of you. Mary says that Ashley was wailing. Yeah, that was brutal to watch. That was brutal. Yeah. Yeah, blessed mom from Texas. That's when the prosecutor did it to her, right? Making her get off the stand and reenact that too much. Friday was so distressing. This is wine cellar infused. Yeah, it was crazy. And yes, Erin says, was she supposed to wait until he killed her to respond? Just crazy what's going on out there. I know. Olyenka says, exactly. I'm still stunned by the total lack of care and humanity the prosecution displayed. I wonder how the jury took it. Yep. Jules did, actually, we didn't talk to Jules after that, and she wasn't there, so she couldn't observe how the jury reacted to that. Yes, I'm shocked. So they found you and Jules during the Maya case. Something crazy happened on that case the other day. For those of you who followed Maya with me, apparently Nick Whitney was fired by Greg Anderson's firm. Somebody sent me some documents the other day. I don't know what happened. I don't know why that happened, but if anybody knows what happened with Nick Whitney, I don't know if anybody's covered
welcome
it.
back, everyone. It's after lunch in 2020 CF 3014. Is the jury up? All right, jury's being brought up. Anything we need to talk about before the defense calls their next witness? Oh, I'm so sorry. I was looking right over top.
I know something's going around in the
That's a good
courtroom.
point. We can check and see if this thing's working again.
It should be.
%, Emma.
All right, looks like my real-time viewer is working again. All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in. Okay.
Yes, Max. He does look like Jim Gaffigan, right?
Yeah.
Justin Warren.
So interesting that Justin Warren, who is the lead detective on this case, was not called in the prosecution's case in chief, because there was some stuff about him that happened pre-trial where I think he may have said something like everyone, like he was considering it a murder right away, confirmation bias. So it's crazy. This is going to be, I think that's going to be the testimony of the afternoon for me, is the lead detective, Justin Warren. I want to find out who Jason Alexander is. I don't think it's going to be the actual, I mean, obviously it's not actually going to be George Costanza, but there's a witness called Jason Alexander that's going to testify. And then the defense is intending, I think, to rest this afternoon, and then they're going to do a charging conference and start talking about jury instructions. So I don't know when there's going to be a rebuttal, or if the state plans to do a rebuttal case.
And everybody's pen is still doing okay? All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. Defense calls Justin Warren.
Oh, here he comes. Lead detective. Oh, with the paper crinkling.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Everybody get your snacks out.
Cool, sir.
Thank you.
Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir.
Your Honor, with the court's permission, permission to treat as adverse.
You can go ahead and approach.
Right away. Right away, he said he wants to treat him as a hostile witness. He wants permission to treat him as an adverse witness. Let's just quickly look up the adverse witness charge in Florida. It means they want... In Florida, a party may call an adverse party or an officer, director, or managing agent of a public or private corporation or a partnership or association, which is an adverse party, and interrogate that person by leading questions and contradict and impeach that person in all respects as if that person had been called by the other side. And there you go. It's basically giving you permission to use leading questions in direct, which is ordinarily not permitted during direct examination. Makes sense, right? First of all, Paula Machado, we don't use all caps in the chat because it's totally distracting and kind of rude. Please stop using Jules. She adds nothing relevant. She's giving us her observations as someone who's sitting in the courtroom. We can't see the jury. She can. So again, if you don't like it, please don't come in here and tell me how to run my channel. Okay? 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 Thanks.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information at the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right, does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Proctor 2.0. Yep. Distance himself as a lead detective. Yeah. Hit the like on the way out, bro. Thanks, Fonzie.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair,
Yes, sir.
with conclusions supported by evidence,
Absolutely. Yes, sir.
not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pre-trial rule.
Just asking the question.
Overruled at this point.
Did you submit an arrest affidavit for Miss Benefield?
Yes, sir.
Did you represent that
Objection, pretrial ruling.
Sustained.
did you describe
Objection, pretrial ruling.
Go ahead and ask your question.
let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from
Objection,
the front.
hearsay.
Sustained.
So he's trying to get him to say that in his arrest warrant, he wrote in the arrest warrant that it did not appear that he was facing Ashley when he was shot, but we clearly heard from the medical examiner that the entrance of the bullet wound into the chest was right next to his right, I think it was his right nipple. And so he's trying to get it out that this lead detective lied in his arrest warrant. Look at my freeze frame game. On point today or what?
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front.
That's not the way that it appeared when we did our preliminary investigation with the medical examiner, and then later on.
And it's your position today as you sit here that
Objection, Judge, can we approach this?
Objection, Judge. This guy's going to make my case look really, 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 really bad because this guy wrote in his arrest warrant to get Ashley arrested for second-degree murder that, based on his opinion, it did not appear that Doug was facing Ashley when she shot him. And that's why all this pretrial misinformation was going out that he was shot in the back. He was not shot in the back. The entrance wound to the bullet that was taken to the chest was to the right nipple or directly adjacent to the right nipple. He's definitely a hostile witness. Yep. So this guy is why everyone keeps saying, but she shot him in the back. That's right. This is the guy. This is why the state of Florida did not call him on their case in chief. Iceman's picking up on it. Detective Warren's face shows disgust and disdain towards Attorney Taylor. They couldn't call him during their case because of this. This is the reason why. That lady Cooley definitely has a mean face on. Why? I think you just heard why. It's like they would have first of all, wasn't his body examined at the scene by the crime scene techs? Didn't this guy, as the lead detective, at least have photographs? If he didn't go on scene before the body was removed, didn't he go to the morgue, go to see him at some point? He was still alive when he was taken away. He wasn't pronounced for a few hours. He could have gotten a verbal. I hate that word too. I do. I hate that word too, Kay. I hate it. Maybe YouTube doesn't like it either, but there's really no other way to describe that part of the chest. So I wanted to make very clear that it was the front of his body, not the back of his body. He wasn't running away. He was coming at her. He was still alive. He was standing in a fighter's stance, like they made her demonstrate, for which she was mocked relentlessly on other. That's even worse. Yuri's math teacher. I think that's an even worse word. Pectoral muscle. Thank you,
All right,
KD.
members of the jury. I'm going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back in as soon as.
Moob. Moob. Kara says moob. Let's say moob. Man boob. Pectoral muscle. That's good. He was still alive. Oh, don't buffer on me now.
We're going to
There's
need to address
Jules.
some legal matters about your testimony that's been invoked, so you're not to discuss questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
Man chest. That's right, Sarah. See how much damage the media can do, and the police use them to their advantage, putting out false information.
All right, the witness is out. So there's, as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve
Nippy. We're going to say nippy.
statements
Thank you,
made
Vice.
by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pretrial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues, so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object.
Is she thumping? She's thumping on something. She's thumping. It's not a great way to make your point. It's like Veruca Salt. I want it now. Apparently, the judge just said that he remembers making that pretrial ruling at the stand your ground hearing, and he says his ruling was, "My ruling may change at the time of trial, but for today, it's not coming in." Veruca Salt.
Object 5 more times. He has clearly only called this witness for impeachment purposes. That is the A1 first objection that I have.
Your investigation sucked.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state?
He's right.
So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders?
Mhm.
If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition.
Wow. Now you know why they called him.
I don't see why that is not a fair game.
That's why they didn't call him, Kim.
Respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield, and he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
No bias.
What report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or checked the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will, and
On that form.
no, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form.
Yep. They could have not called him, and then the defense gets a missing witness charge, which looks very bad to the jury.
Which,
It says bias motivation, he types in none, no bias. The next block says bias target, it's blank, and the box after that says bias circumstances, that too is left blank. Would you like me to show you?
Yes.
first, I don't think he filled that out.
That's right, Moon Goddess. He said all homicides are murder in his deposition.
The court in deposition. No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
We promise if you put your DNA on the like button, the Canton PD won't get a hold of it. Neither will Proctor. If you know, you know.
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning that the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. And I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Judge, I feel like we litigated all of this.
Yeah,
And
for a different reason, ma'am, counselor.
this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He
Stuff.
calls him and says, these
Counselor, the stuff is called bias, confirmation bias.
questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment.
He's your
We have
detective.
gone over this before, that what is in this arrest affidavit is irrelevant.
No, it's the
What
reason she
the
was
judge
arrested. Really? Are you seriously arguing in front of a judge right now on worldwide television that what's in the arrest affidavit is irrelevant? It is the charging document. It is what causes her to be arrested. It's irrelevant? Am I losing my mind out there? Jamie, you're a lawyer, right? Am I losing my mind that it's irrelevant what's in the arrest affidavit? Fun Pack says, Vince Vaughn in Couples Retreat, you're a problem. You're a real problem. What I want to scream at the prosecutor. Love that movie. Love Vince Vaughn.
Signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why
Because you didn't
attacking
call
the
him.
credibility of a witness that never testified?
Because you never called him for specifically this exact reason. And now you're going to get all haughty about it? You chose not to call him because you knew that he was going to tank your case. Pin it on the girl, Lula.
So as I understood the
Final
court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings. Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least two deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there has been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes.
That's right.
How could that not be relevant?
Of course. Agreed.
This witness never testified.
Any further thoughts?
You didn't
No.
call him?
All right. Yeah, these, we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness. And the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But
Missing witness
the
charge.
answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record.
Well, now he wants to disagree with what you're saying.
The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are killer murderers.
Because they didn't investigate the self-defense claim of this case and just charged her with second-degree murder. I am undergoing wicked storms right now, thunder, lightning, all of it. So if I disappear, hang tight. I'll be right back. I'm going to disagree with him on this. That goes to the very heart of the investigation, the very fact that she was even charged to begin with. Some of the jury may be thinking, what are we even doing here? If they're thinking like some of you are, why are we even here? It was clearly self-defense. The reason we're here is because this guy never even looked at self-defense as an option, because in his opinion, all homicides are murders. There's going to be many defendants clamoring at the prison doors today who had this guy as a lead investigator on their case to show that he's biased, try and get their convictions overturned. Let's just see what happens here.
That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified? That would be his opinion. But if that was his opinion, she might not be sitting there right now.
Mm-hmm.
That's why I think it's relevant. He initiated the prosecution.
Yeah.
And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
Yeah, true. Truth. I don't understand either.
State anything else?
Why he's struggling to understand quit ruling the planet,
Yeah.
okay?
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
It's going to go to
All
a
right, I
tainted
have 2
investigation.
questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
I have,
Well, hold on.
okay.
The 2 questions that have been stated at this point, the 2 questions, just to try and get objections out of the way and get them ruled on so we can get this going, is 1, 2 is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to
I
that.
think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA.
DNA report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall crime scene swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Miss Benefield testified.
Wait, hold up. So they found Doug's touch DNA on Ashley? Hold on. Now they don't want this because he laid hands on her? You see what's going on here? AJ Hartung says this is exactly what happened with a certain Massachusetts detective opinion on Karen Reed. Right. But what happened in that case is Proctor was called to the stand by the Commonwealth. That's the difference here. Florida, the state did not call this guy to the stand for these exact reasons. But now they're saying you can't use his bias against him because you're just trying to impeach him. But isn't he the guy who steered the entire investigation? I don't know. Different interpretation of the law. Let's hear. I want to hear more about this DNA report.
Swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Miss Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around,
That's right.
and blocked the door so she couldn't get out.
That was her testimony.
Okay, go ahead.
My objection are not to the business record certification, Judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay. There is not a person at DNA labs that can say where those swabs came from. They only know.
Your crime scene tech testified about swabbing her. So now you're going to argue that the results are not accurate? Okay. Do they not? They really, it's like they don't want the truth. They just want to win. If Doug Benefield's DNA was found on her wrists and arms, like she said, he grabbed her, spun her around and said, "You're not leaving me," or something like that. Let's call in someone from the labs to authenticate it. Let's call back your crime scene tech that swabbed her and go through the chain of custody on those swabs and where they were sent and who rendered the report and who interpreted the report. Let's put the onus on the defendant to pay for all of those people to come in and testify because the state doesn't want it in.
Know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this, and that there's a unfair prejudice.
Unfair prejudice? You can't use it as a shield and a sword. You use DNA to convict how many defendants a week, counselor? And now it's going to be prejudicial to you that Doug Benefield's DNA was found on Ashley's arm and wrists when your entire case is that she was not acting in self-defense and that proves that he laid hands on her? Okay.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands,
Right.
arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now,
I just want to point out now, while Ashley's on the screen here, is that people in other chats are pointing out that the gray hairs that she has were intentionally painted there by her to make herself look sympathetic and stressed out. You just can't make this up, my friends. You just can't make it up.
I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them.
The DNA swabber already testified,
Right,
not your
mhm.
edits.
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no established.
So you're saying your crime scene tech sent somebody else's swabs in there that just happened to have Doug Benefield's DNA on him? Is that what you're saying? You're going to say that your crime scene techs are screwing up somebody else's swabs had Doug Benefield's DNA on it? What? I can't even believe this argument right now.
that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, that I already said all those things, but it's just frustrating because they're all the steps to get that report in under certified business records have been skipped. And so although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
It's exculpatory evidence, in my opinion. Right? If they didn't bring it out on their case in chief, why can't the defense bring it out? It's their results from their lab. I think it's their in-house lab.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be broken.
But if it's this lead detective's opinion that all homicides are murders and he's not believing her self-defense claim, and then he gets a DNA report that shows Doug Benefield's DNA on her body, why didn't that change his opinion with regard to whether or not this was a murder? See how all of these things are intertwined? And if he's going to require the defense to call in all those other witnesses, this case is going to last another day. Because I think it needs to come in. And maybe he's right about foundation, but you can see how shady people may think worldwide that our system is behaving, because this is potentially exculpatory.
Prohibited crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant. And you can ask him, I think, if that's his supplemental report. I think it's close, but I'll let you ask him, here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about, and aren't solely to impeach. So, all right,
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and
Yeah.
speaking what's on the report before the witness even says he wrote it or anything. So
Right.
I would
So
prefer that he not.
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in.
All right, there's a foundational basis for his ruling on that. However, I do think that the defense should take the time to call those witnesses because, in my opinion, that's exculpatory evidence, backs up her self-defense claim, or just adds more fuel to it.
a seat. Welcome back, everybody. Did you begin deliberating amongst yourselves? Talk to anybody outside the jury about the case? Or do any research on people, places, things, or legal topics? No. Everybody says no. You may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
Good point, Nicole. Why does prosecution depend so heavily on DNA when it works in their favor, but as soon as it contradicts them, it's not allowed? What a bunch of hypocrites. Under the rules, you do need to show foundation, so I can see. I can see why he ruled that way.
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
Yeah, you documented in your report, did you not?
Yes, sir.
All right, my last question, Detective.
So he did speak to him. He just said he didn't speak to him, but he did speak to him on October 29th. I remember her arrest was not until something like November 2nd, because that's when I think when the mug shots were dated. So he did talk to the ME about stippling.
Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify?
Fill out a lot of reports. Show me the receipts, Jennifer McCabe. He's going to the Jen McCabe School of Witness Testimony.
November to be. Yes.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
Okay.
did you put in none?
Bias and motivation.
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
Okay. The reason that's important is because ill will, spite, or evil intent is needed to prove a depraved heart or a depraved mind. And that's an element of second-degree murder that she's charged with. Yeah, he's blaming a program. So he's saying it auto-populates, and he wouldn't necessarily put it there. He would put it in a different part of the report. That's an element of this crime.
Crimes. This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box.
Okay.
But
So this box is for those.
You don't pay attention to that box typically? It's not an important thing to fill out? That doesn't look good for him.
Kind of statistics, not for any kind of bias that may be going on in this case.
correct.
Thank you.
Redirect.
He's never investigated a hate crime? Okay.
Do you think it odd that you were the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
He said, do you think it's odd that you're the lead detective in this case and you weren't called by the state?
No further, nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
They have my email. Okay. Oopsies.
We call Dr. Michael Hay.
I don't know who this is, Michael Haig, but we will find out. The papers. Oh, we complain when they're rustling the papers. We complain when we don't get the volume loud enough. So I'd rather have some volume and be able to hear the testimony than have, if I got to suffer through papers wrinkling in my ears, I guess. Crinkling. It's a small price to pay.
Just speak in a loud, clear voice, you don't pick up anything.
Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haig, H-A-A-G.
What type of work do you do, Mr. Hay?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a bachelor's of science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
It's wicked
When
smart.
you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haig, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the police.
Okay, we've got a guy. We've got a guy who's going to reconstruct the shooting for us, you guys. This is exciting. This is fun stuff. Physics, chemistry, forensics. Love it. Pay attention.
Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taken classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. If you can spell it. Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Toolmark Examiners, or AFTI, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any?
Just to clear up any confusion, I think some people thought when people were saying, is he a good egg, that they were referring to his bald head, but we were going back to the Willy Wonka reference of Veruca Salt. So nobody was saying anything rude about his opinion, about his appearance at all. This was a Willy Wonka reference. If you were confused, now it's explained. Thanks. Not you, Scott. Somebody else was talking about it.
Scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Toolmark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haig, any forensic presentations of note?
I very regularly present, both at conferences as well as for organizations, on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which certification applies to an individual and accreditation applies to a laboratory, so those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial.
Wow.
I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I worked cases from Iraq and many other places that I lose track of.
Okay,
Are
if you're
you an
behind in the
instructor
stream, if you're
in any
behind in the
areas?
stream and you're commenting, realize that your comments are coming into real time. So we do now understand that the closed captions referred to him as Dr. Egg. So if you're behind in the stream and you're commenting in real time, just be aware of that. He testified in the Aaron Hernandez case. You guys from the Karen Reed case might remember that one. It's right up there in your neck of the woods.
Forensics.
I am.
You've written on the subject as well,
I have.
and you provide regular training in shooting reconstruction.
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So This is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It can involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene, and then you move that system from one place to the next. So you can move around corners and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And
The crime scene doesn't need to speak to him because he takes the crime scene with him. Azimuth has entered the chat. And Susie Q is feeling like a celebrity. Hi, Susie Q. Because she got her comment highlighted. I love that.
since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
All right.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform.
Okay, people are saying in the chat the first wife has passed away. The first one? The second one I know has passed away. I don't know about the first one. His first wife was when he was 28. He was married to for 6 months, so I don't know about that.
Myself on what evidence, what pieces of that
Ashley was his third wife, just to clarify things.
puzzle on the table to include particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
3D laser scanner. Love that.
And in this case, did you examine all
they're
the
both
evidence
deceased?
that was available to you?
Thanks.
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets.
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office, crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand in a way where they'd been. And this is sort of one of my main areas of interest is the damage to projectiles sometimes, depending on their condition when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile.
Thank you for pointing this out. It went by too quickly, so I don't know who pointed it out, but whoever did gets the credit. Extra credit from me, your teacher today. Scrolling underneath the expert's name, it says, and I quote, "The medical examiner does not believe Doug was facing Ashley when she fired 4 rounds at him." We know from the medical examiner's testimony that that's incorrect. So the fact that it's scrolling underneath this witness's testimony is a little concerning to me because it's inaccurate. Right? Okay. Oh, maybe I can get Michael on my show. So here's the misinformation being spread right there for you to see on the Law and Crime Scroll.
Projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo or created through intense engineering by people at the companies such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't overpenetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see overpenetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, assumption that the firearm, if you're the firearm, I mentioned right to left.
All right, that just skipped. That wasn't us, that was them. And this is important testimony because it goes to where the bullets entered. All right, he's telling his opinions. We were a little bit before this.
And each one has a story to tell about
Tissue. We're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have two things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
There it is again. He pointed at the front of his chest, right next to the nip.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity, we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects in the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom. And we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you, with regard to sequencing, which one was first. But if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right, that's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have...
Wow. Did you hear that? You don't take the witness statement and believe it. You have to cross. Wow. Hold on, because I think that Canton PD, maybe the MSP needs to be paying attention to this witness. You never take a witness statement at its truth. You got to cross check it with the physical evidence as such. John O'Keefe was not hit by a car. No matter what some people in that house want you to believe. Listen up.
Witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body. But because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
David Reese, I'll allow it. Wants to know, can we call him the shot daddy? I'll allow it. Thanks for the super chat.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident, or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such.
Okay, if you're not watching your screen because you're cleaning your house and you just have your earbuds in, you might want to go watch the screen just now if you can, not if you're driving, because he's going to point now where he thinks the trajectories were and where he believes the bullets entered Doug Benefield's body, which he also said was moving at the time. So pay attention. He is communicating really well, facing the jury professionally, like the expert witness. They are good for the defense. They're great. He explains things really clearly, I think. If you're ahead, please, no spoilers.
Things front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way. And as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically 2 relatively opposing trajectories on an object that undeniably, in my work, bodies regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right.
The body was in motion. But what I would like somebody to do is to clarify the record, because when he says in the record, it entered here and exited here, I would always clear up the records and say, okay, you're indicating it entered on the right side of his chest next to his nip and exited or landed or came to rest at a point, below the left scapula. Is that what you're saying? Because that way the record is clear, because it's not a video record of this trial. It's going to be a written transcript. But aside from that, great testimony if you're watching him and you can see what he's talking about.
And with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before, with the 2 trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those 2 trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
All right. Love the
Please, Ron.
visuals.
Thank you.
The 3D scan data.
Please.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Hey, can you,
Mr. Hagan, I'm sorry to interrupt.
Please.
This is the room.
can you show it on TV? Thank you. I'm going to full screen this for a second so you can see it in all its glory.
Where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
This is so cool. If you're not watching, come back to the screen so you can see this. Really totally cool 3D rendering.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room.
Now you can see how tiny that room was, and you can see that if she felt trapped in there, she might be feeling really trapped in there, right? She was boxed in, only one way out. She was really cornered. You guys are saying this is microdot style.
Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11, maybe. But if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there's an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that. And I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that. So green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5-degree cones, I talked about the error earlier, on both of these, we can see that those 2 cones look like that. That's actually a 10-degree cone. for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down.
So cool.
And from
It gives me Dexter vibes too, except instead of blood spatter, it's bullet trajectory, which is so cool. I'm wondering what the dimensions of the room are too, because it looks really small. I would love to know the square footage of that room. So if you're not watching the screen, come watch the screen because this is really cool.
From this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Ms. Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Nagin,
yeah.
As to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent.
Diane from Tampa says, but she just happens to pick the room that has 2 guns in it. A lot of questions for me. She testified that he blocked her from leaving out the front door. So she ran into that room and closed the door. And the next thing she heard was him banging the door open and the door slamming against the wall. So she ran in there. He followed her. That was her testimony. Chat, you can correct me if I'm wrong.
If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
And that's another bullet, is that correct?
Correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those 2.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct? But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're 2 separate trajectories that have some slight divergence in the lateral aspect.
Okay. Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is
degrees.
an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haig, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Nothing is inconsistent with the way that she has described this incident happening, he said. Jean Marie says, I've never seen a bedroom door with no lock. This is not an old home. My children do not have locks on their bedroom doors. Is there anybody else out there who has bedroom doors in their house that do not have locks on them? I mean, unless you're living in a house with a bunch of roommates that you don't know. My kids don't have locks on their bedroom doors. I would never want them to be able to lock themselves in. But, you know, if there's one person on the jury who thinks that, why didn't she just go in there and lock the door?
Yes, sir.
Catch up a little bit.
Just have a couple.
Thank you, Mr. Haig.
Okay, nothing more. So now we're going across, everyone. Ready, go.
Cross.
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the 2 shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body
Straight.
This way?
None of this is going to be clearly on the record. I hate when they do this and they don't verbalize it. The attorney should verbalize it. But if you're not watching, watch, because you need to see what he's demonstrating and what I mean, in her opening statement, the defense attorney said in her opening statement and demonstrated that the shot was from side to side, pointing at both, upper hips, both sides of her waist. That's how she said he was shot, from side to side. Do you remember? Does everyone remember that? Okay, listen up.
Right. Can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes. I'd have no way of, correct, yeah.
Thank you. No further questions.
Redirect.
No, sir.
Can this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thanks, sir.
Thank you.
All right.
It's
That
going
was
to take you a minute to put that away, and it's about 10 minutes after 3, so I want to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it. and we'll get you back out here as soon as we can.
Oh, I love how he lets them go get snacks, take a little break. Then we get to catch up to real time because we have about 6 minutes left in their break. We can go to the questions. One of the best expert witnesses I've ever seen. I found him to be very easy to understand. The way he explained things, like as if anybody could understand. Let's say you. Karen Stoppel, thank you for tuning in from Canada. Said, Melanie, I can't believe you did 30 years in court. You look far too young. Oh, thank you very much. It's a really good lighting. All about the lighting. Ring lights can do wonders. V Take Sue, thanks for the 5. On the question of Greg Anderson and Nick Whitney, there's a bit of tea spilt about the firing and leaving. Oh, yeah? I just saw the original court documents and I was curious about that. So I don't know. Who's got the coverage? Moselle Conger, thanks for the 5. What's up with all these prosecutors lately not wanting to find the truth? Shouldn't the judicial system require the truth? I'm so disappointed. Yeah. Shouldn't they? Shouldn't they want to know the truth? But also, the rules of evidence are important. Constitution is important. And the rule of law is important. So if they need to lay a foundation to get that DNA evidence in, I say, let them do it. No rush. We're not in a rush here, right? Kathy, thanks for the 5. Oh, how I wish your commentary was allowed in as evidence. Oh, thanks, Kathy. Thank you. Stephen Mnemonic says we're being gaslit in real time by this DA. Thanks, Stephen, for the deuce. Blessed Mom from Texas, you're so generous always. Congratulations on 66K. Please like the video and hit that subscribe button. It's free. Bell for notifications. Let's go to 70,000. Yeah. For those of you who don't know, I'm in a secret, unofficial competition against Vinnie Politan to beat him in his YouTube subscriber numbers. Now, I have just hit 66,000. My channel is just a year old, and I need to go to Vinny's private channel to see what he's up to so you can help me in my quest. He's at almost 71,000. So we're getting up. We're within 5,000 of him. So if you would hit that subscribe button for me, it's totally free. And that would be really awesome. Thank you. Thanks, Blessed Mom from Texas. And thanks, Jilly Bean, for the 10. Why is evidence of DV needed to claim Florida's stand your ground defense rights? It's not. It's not. I know we didn't want to derail the chat earlier by talking about the Zimmerman case, which was the popcorn case, and I don't want to derail it again now, but I'm going to say that stand your ground does not require DV. Battered spouse does. Stand your ground does not. If you are in your own home and someone comes into your own home in Florida and you feel afraid for your life, that you are in imminent fear of bodily injury or severe bodily injury or death, you have the right to use deadly force in your own home. And you do not have the duty to retreat as you do in many other states. So 2 separate issues, Dilly Bean. Hope that cleared it up. Tina T, thanks for coming in for the super chat. Hello again from Dubai. I know abuse when I see it. Thank you for tuning in from Dubai, and I'm sorry about that. Thank you for your super chat. Jody Arrington, thanks so much for the 10. Much gratitude to you, Melanie, for your unwavering dedication, loyalty, intelligence, and grace to all the cases you believe in and to your audience. Oh, you flatter me with compliments. Thank you, Jody. I appreciate you. People are calling me all kinds of things out there, even in my own comments, which I find to be mind-numbing. Somebody called me deranged yesterday. In my own comments, like said, you, Melanie, is deranged. It was okay. If believing that a defendant should be deemed innocent until if and when proven guilty, then call me deranged. I've been called worse. So thanks for that. David Reese says she went into her bedroom because it's a safe space. Most people also keep their weapons in their bedrooms. Thank you, David. And in fact, I think they also said they had one in the pantry and she had one in her purse, which was her backpack. People were saying the guns should have been packed away in the U-Haul. Like, what? Would you pack your gun in the U-Haul? I don't know. Listen, I'm not a gun person. I don't live in a really gun-friendly state. New York is not, like an open carry state. But people in the chat can tell you that there are other states who do believe in open carry. Oklahoma is one of them. And you're allowed to, as long as it's visible. Carry your gun around wherever you go. So the laws from state to state vary wildly. And just because I don't have 5 guns doesn't mean that other people are not allowed to under our Constitution, right? Town Crier, thanks for the 5. If Mr. MMA fighter was going to attempt a spinning roundhouse kick to disarm her, he could have been shot as described. A lot of people pointed that out the day we heard that testimony. Thank you for that. Nina, why was the stand your ground defense not allowed? Okay. Hi, Nina. Thanks for tuning in. It is allowed. It was not, the case was not dismissed on stand your ground immunity, which means that about a year ago, the defense made a motion to dismiss the case, saying there's clear evidence that Ashley Benefield was defending herself under stand your ground and the charges should be dismissed under stand your ground immunity. She did not testify at that hearing. The court found, because when you rule on a motion to dismiss, you have to view the evidence in the light most favorable to the prosecution. So the court ruled that based on its review of the evidence and the 2 days of hearings that it had with many of the same witnesses we've seen in this trial, that as a matter of law, he could not dismiss the charges. Now that Ashley has testified, that changes things. They're still allowed to use it as a jury charge. See what I'm saying? So it's not that they can't use it, it's that the case was not dismissed a year ago on those grounds. Zimmerman shot a kid who walked by. He had a hoodie and skin. I don't remember. I think it was about popcorn, Laura. I don't really know. I don't want to derail the chat on that right now. Thanks for the super chat, but it kind of got derailed earlier talking about that, which is not exactly on topic. And so we want to try and just keep it there for a little bit. A little bit. Popcorn was a different case? Okay, then I don't know. Zimmerman was a different case than popcorn? Yeah, I don't know. Yeah, and people do say that people should put the guns in the U-Haul. A lot of people said that earlier. A lot of the comments were flying by about that. Thanks, Terry. Melanie and Mods, are there other ways to send money so demonetizing YouTube does not get a cut? Yeah, that's why I put the Venmo up there and the Buy Me a Coffee and the Cash App. So those are great ways to support creators because YouTube takes at least 30% of all super chats. And also, I'll still read your question on the air, unless you say Anon, please, in which case I won't. So thanks for asking, Terry. Appreciate you. Thank you so very, very, very much. Only damn Yankee said the guns should be. Curtis Reeves was the popcorn case. All right. Michael Haig is riveting. And they said that it was his dad that testified in the Rust case. His father is also an expert in such things as reconstruction. So there's that. Oh, the picture with the cat behind me? That's a Dave Matthews tour poster. Can you see it? Not really so much, let's say. It says Dave Matthews Band. That was their tour poster from, looks like 2023, Madison Square Garden, I think. I'm going to rotate them in and out. And then that's the Grateful Dead and Company. Dead and Company behind me. So thank you. Thank you very much for loving my background. Why don't we take a quick 2-minute break? Everyone take themselves a comfort break. I'll be back in 2 minutes in time for court. Put the break sign up, and I'll see you in 2. Okay, the court is back, and so are we. Defense said they have 2 more witnesses today, so we'll see who comes up next.
You will be the truth, the whole
Good afternoon, Doctor. My name is Judge Wright. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches.
Yes, thank you, Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right,
Right on,
Dr.
Dog.
Lew. Let's take a moment. Let me just run you through your undergraduate education. Where
Yes.
did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a 1-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Lew?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Lew, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Line's security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Lew, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And
That's a great explanation. That's a great explanation. You could say someone's beautiful if you think so. Compliments are welcome. She is beautiful. We don't like derogatory comments about people's looks, but it's okay to see that someone's beautiful.
The gunshot wound.
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Okay, she said it again, a little bit louder for people in the back. A little bit to the right side of the nipple. Let's hear it again.
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
Yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right fifth rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you.
So that one was back to front through the right thigh, came out below the right knee. So if someone's legs were up in the air, could have been an upward, she'll tell us. I don't want to try and figure it out, but you see what I'm saying? She did say that he fell and his legs went up in the air. So she pulled the trigger again after the chest shot and he fell. She shot again. It would go through the back of his thigh, out below the front of his knee. Got it? Okay, I got it.
You picture and have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay, so how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up.
Catch up a little bit.
So you can see what's going on.
With court's permission,
Yes,
I
ma'am, you
ask
can step
Dr.
down.
Liu to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw it.
Okay.
You have a preference of which one you'd like to start with? Okay, this one.
On the outside is the
That's what that represents, Dr. Liu.
Well, you know what, cameraman? It would be your camera person. Sorry. It'd be really helpful if you showed us what she's looking at. Show us the easel instead of Ashley's face. That'd be great, okay? Thanks, XOXO. Love you.
This is the graze or superficial gunshot wound on the outside of the right upper arm. I know there's a
Yes, a rod.
point, a little rod on the
We have three.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin,
I know she's hard to understand. I'm going to put the captions back on. I took them off earlier because they were blocking our cool 3D image and I forgot to put them back. So I'm going to rewind it so you can hear her testimony. I don't know if the camera person is in a bad spot and he's not going to be able to get, if there's only one camera in the courtroom, he's not going to be able to get the front of this exhibit for us, but it would be so great if we could see what she's talking about as she's pointing it out. Thank you, Laura, for the super chat. Training and experience. That's how she knows all this. She says, medical examiner mama and gunshot daddy saving Ashley justice. Thanks, Laura.
now the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this D shape? tag. And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back, going from front to back and upward. And because it's on this part of the line, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may,
Yeah, the pictures could be graphic. You're right. Good point. I thought maybe it was a diagram, but maybe they're actual autopsy photos.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in the hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of the lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where
She's saying that that shot to his spine would have caused paralysis to the legs.
but not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
all right. I think you can probably return to your seat if you like.
Okay, Mystery Singer, I'm just going to point out, Mystery Singer says, I would be crying right now, but even when Ashley is crying, there's no tears. Do you see that woman sitting behind Ashley? She's a court watcher. Her name's Jules. She went to the Maya trial every day. She's been in court every day, and she came on and she called in and said 100% there were tears, there was snot, there was everything. So I don't know where you're getting that from, but this woman is sitting in the courtroom and she's seen it. Don't believe everything you read on the internet. Well, I will also point out that there are certain medications, such as like Wellbutrin, that can prevent somebody from being able to produce tears. So there you go. Oh, yeah, like Kimmy said, I'm on antidepressants. Can't produce tears. JD Lion, we're watching Ashley disassociating in real time. Yeah, it's scary.
Let me see if I can know.
Well, she cracked a little smile.
Not too much. Testifying, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
Oh, she wants to do a demo too.
At the time that you
Maybe not.
observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Hearsay, Judge.
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection, relevance.
I'll sustain.
Were you struck? Yeah, I don't like the wording of that question. Prosecution's going to try and spin it to say that Ashley knew what the autopsy results said, and therefore she crafted her testimony around it. But this doctor is saying she spoke to Ashley a year ago, and that she doesn't think Ashley had the autopsy results. And even if she did, she wouldn't be able to extrapolate that back into her reenactment of the shooting. So that's good testimony for the defense.
Question, Dr. Liu, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times,
Wow.
and then maybe 20 some times more after I retired.
Wow.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Liu. Give me just a moment, Your Honor.
500. She testified 500 times while she was a sitting medical examiner, and most of those times it was for the state.
Right. It'd be helpful if, Dr. Liu, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
All right.
Judge,
go to a
with
new
your permission,
dimension.
May I?
Yes.
Come on up, Will.
A new dimension. Put some Twilight Zone emojis in the
May I
chat,
step
members.
down, Your Honor?
Yes, ma'am, please do.
May Dr. Liu step down?
I like when they allow them to do demos.
First gunshot.
But are we going to be able to see it?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield.
It's hard to hear her now because she moved away from the mic, but she says she thinks the grazing gunshot wound was the first one to his arm.
Was coming towards.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Liu. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
Alrighty then, you can approach. You can catch up a little bit.
Dr. Luke, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm raised gunshot wound was the first shot.
Are you able to say why? What independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Liu, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
The right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
The right side facing.
Judge, I'm confused as to what we're demonstrating.
We're demonstrating the shot to the leg.
Yes.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand and reposition yourself.
Now, the entrance was on the right side of the okay. The entrance was on the right side of the back of the cab, and the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while it's on the ground, with the gun being in this position. So it's going in here.
They're not showing the demonstration. They're focused on Ashley right now, who's got her head in her hands and her hair blocking the side of her face so we can't see. But I would like to see the demonstration if they could show it, but they're not going to. For whatever reason, not graphic, just because they'd rather focus on Ashley, I guess.
And coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg.
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr. Liu. You can take the witness stand.
They probably couldn't show the demo without getting the jury in frame, so that's probably why they couldn't show it. Someone's saying she was not 24, she was 28 when this happened. She was 24 when they got married, so I'm just going to delete that comment so that we don't have any misinformation in the chat. She was 24 when they got married. She was 28 on the day of the shooting.
Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Liu. I have no further questions, Your Honor.
She's now 32.
I just want to ask you about the leg wound.
Yes.
For a moment. You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay. So there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly,
So,
yes.
possibly. So if he is walking towards someone, we fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay. All right. And you spoke about the abraded contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head would be struck on something, because the contusion is a bruise, which requires blunt force.
Right.
Blunt force
So if,
trauma.
for instance, he was being drug out and hit the door jamb or something, bounced his head.
Do you think that now are you going to say that the EMTs dragged him out and they weren't careful about it and then he slammed his head against the door jamb? Really? He was still alive. Is that what you want to go with, prosecutor? I got to hear that again. I got to hear that again.
There's blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of abraded contusion on the head?
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
That is an odd hill to die on, Debbie Jo.
Dr. Liu, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Oh, she's demonstrating. Look.
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how That would be consistent.
Ah, consistent with
That's all.
lunging. Excellent redirect. Excellent redirect. Yeah, you're pretty sure they have stretchers, but for some reason, Cam, they did have to drag him out, and they testified to that. I'm pretty sure, though, they didn't slam his head against the door jamb. And you could see how small that room was. I don't know if for whatever reason they had to drag him out. It was crazy, I know. Harley, we said the same thing. Boom.
Thank you.
Do you have any questions on that?
No.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much.
She's amazing. I want her in every trial. We have her in every trial. She's very zen. Found her to be a very calming presence in what has been otherwise.
All right, Mr. Taylor?
We have this one issue left.
Okay. All right.
It's been a very stressful trial. Aside from Dr. Liu's testimony, I found her to be a very calming presence. Was Monty Python the prosecutor EMT team? All right, we appreciate the jokes. Say no more.
Members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back and see you.
'Tis only a flesh wound.
No, this is,
Was this the issue, the Richardson?
no, this is the DNA issue.
Oh, yes.
And I have the following case for the court.
Oh, good. Case on the DNA issue. If you're just tuning in, welcome. Defense called the lead investigator to the stand this morning, Detective Justin Warren, because the prosecution did not call him. And while he was on the stand, not only did they try and get him to admit that he said in prior depositions, or a deposition, that all homicides are murders, and that he had decided within 45 minutes that this too was a murder, that self-defense did not apply here, which was not allowed. They also tried to enter a DNA report, which indicates that the crime scene technician we heard from during the state's case had swabbed both of Ashley's hands and her wrists and arms for DNA. And the DNA report indicates that Doug Benefield's DNA was found, or touch DNA was found on Ashley's arms and or wrists. The judge would not allow that testimony in via the detective. And so now he found a case to prove his point. There's always a case. I used to tell myself and my associates when I wanted them to research an issue, there's always a case to support your position. There's always a case. You just have to go find it and make sure that it's still good law. So let's see what he found.
Ladies,
Thank you.
Bill.
Yes, sir.
Exactly. The bedroom was really tiny. It may be difficult to negotiate a stretcher plus the two EMTs. That's what I was thinking. The judge is reading the case, so we'll see what he says. You didn't see what Ashley just did. She just coughed into her elbow, which is such a mom thing to do. Love that. Good, we can catch up to real time, hopefully. Before the internet, we had to go to the law library, Mark, and search for cases there. And then you'd have to look them up, and then you'd have to find them, and then you'd have to shepherdize it in a little paper insert to make sure it was still good law. It hadn't been overruled, and it took forever. So law libraries are for, we're for. And There was always a law library in the courthouse too. So if you needed to do some legal research, you could run right up to the law library. Hmm.
Okay, so go ahead, sir. I've had a chance to review shorter.
Shorter, that's the name of the case.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor.
Yeah, if that case is on point, he's right.
So, I can't imagine that.
And I thought there'd have to be a case on that because it is their DNA report. And they did not introduce it, so shouldn't he be allowed to introduce it in the interest of fairness because it's exculpatory? Didn't I make the same argument before? I don't know if I'm going to win this argument, but he found the case. The case was out there.
The state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody.
Right.
So we think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Are they going to, so it's like they're contesting their own chain of
I thought I
custody.
made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact.
But your crime scene technician testified that she swabbed her. I mean, it's mind-numbing that they're going to argue against this when it's their own report and their crime scene technician did the DNA swabbing.
That those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that.
But let me put this in the reverse, ma'am. If that DNA report said that it did not contain Doug Benefield's DNA, would you have introduced it into evidence then? I think you probably would have. You see what's going on here, folks? See what's going on? Shield and sword, shield and sword.
The same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections. Because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA. And it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things. And I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents And that there hasn't been an adequate
Okay.
foundation and that they're confused.
Okay. It's not a Brady violation because my understanding is this is the state's lab's DNA report, right? This is not an independent lab's report. This is the results of the report that their own crime scene technician did. And because it hurts them, they don't want it in. They can argue to the jury later that there could have been other ways that Doug Benefield's DNA would be on her wrists and arms. He was giving her a arm rub or something earlier in the day. I don't know. But as far as I'm concerned, this is not, as far as my understanding, this is not an independent lab that the defense hired. You can correct me if I'm wrong in the chat.
Sure. Rebuttal?
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorbeck testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any chain of custody is irrelevant, even though they've just basically undermined their own chain of custody. It's not an issue.
You can't trust this chain of custody.
For our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as
I want to read the case.
an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or a report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst.
Bring him in.
It lists a number of items.
Come on, Jerome. Come on in.
14 different items that were apparently sent to DNA Labs for DNA testing.
It's in the case folder.
And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says,
Martha, the judge doesn't always get it right. That's why there's appeals. Just saying. Let's hear what he has to say.
that the testing was done. Mixture of 2 individuals, at least 1 male contributor. says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, two different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and two unknown persons than if it originated from Ashley Benefield and three unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and two unknown persons contributed to the profile rather than Ashley Benefield and three unknown persons.
So now it has to read that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and three unknown persons than if it originated from Ashley Benefield, John Sant, and two unknown persons. Therefore, there is extremely strong support that Ashley Benefield and three unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and two unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison.
Okay. David says,
All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important.
it's the state's
That's why we have
report.
it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody a chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403.
Yeah, the state could stipulate, but they're not going to on it because they don't want it because it kills their case. It's crazy, right? Yeah, shouldn't there be a chain of custody log? That's a great point, Trish.
And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says, and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is,
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said two sentences. Yeah, these two sentences that are highlighted.
correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared.
Well,
So
that was
I
the
mean,
state's lab. Why would they? They already decided within 45 minutes this was a murder, Judge. So there's that.
I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would,
Yeah, make your record.
so, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these two sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, an inch and a half tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those two sentences. This is the full report.
All right. So it would
Okay.
be your intention to admit into evidence Defendant's Exhibit 29. What is this in here? Or does this go in here?
Yeah, no, that I believe is in there. This comes back. Oh, I'm sorry, Ron, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right. Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Oh, wait. Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer
Yeah.
as to precisely why I think it should be admissible.
Yes, sir.
Under the case
Okay.
that he found.
So, unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence. In this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and two unknown persons than if it originated from Ashley Benefield and three unknown persons. Now, maybe I misunderstand this, Your Honor, but to me, what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
All right, thank you. Do you want that right after the first page?
You put it right on top.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
So I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the fourth DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow?
Cool.
And it would have to be by Zoom.
It'd have to be by Zoom, but he can come in. That DNA lab guy can come in after 2 tomorrow by Zoom. Good. If justice needs to be served, that's what we got to do. We got to do what we got to do. We haven't taken 1.5 million days like in Judge Cannoni's courtroom. We haven't taken Fridays off. We haven't had early, summer Fridays, spring Thursdays, happy hour Tuesdays. Let's see.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen.
What does that mean?
So
I gotta look that up.
we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that,
Kelly Reed?
then we will rest.
All right, well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect, it was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
Mm-hmm. So do you have a?
We'll rest.
Okay, let me bring the jury in.
So the new
I
rule says
will,
they can't do a witness by Zoom in a live trial. So he's resting because they're not going to allow this exculpatory evidence in when the witness is available tomorrow after 2, but only by Zoom. It's crazy.
We can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with the 9 o'clock start.
Yeah, why are they in such a rush to end the trial, Robin? Woman's life is on the line and they want to
The court
rush?
has it.
I will have to look.
Copy of it, so we thought the court may recall requested copies of the proposed homicide charge. And we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I want the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, so is there any civil juries or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have a.
We're a little bit behind, so let's move forward.
With me, but I have a whole other pile. I'm going to go upstairs, and I don't have it in the pile. All right, I'm going to have to give you all. Let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run.
All right, let's see. This Florida Rule 3.116 says that any party desiring to present testimony through communication technology, meaning Zoom, must, prior to the hearing or trial at which the testimony is to be presented, contact all parties to determine whether each party consents to this form of testimony. The party seeking to present the testimony must move for permission to present this testimony through communication technology, which motion must set forth good cause as to why the testimony should be allowed in this form. I mean, so I guess that state is there. He's assuming the state won't consent to that. And so therefore, it's just Taylor's not going to fight it. That's disappointing because in my mind, that's exculpatory evidence. David Reese, thanks for 10. It's been my experience that people who own firearms keep positive control when moving. U-Haul trucks do not get broken into. Do get broken into. Yeah, I would say that I wouldn't think that people would pack their guns in a U-Haul instead of leaving them in their house where they can access them and have them within sight. I don't know. My opinion as well. Reclined 1, thanks for the 10. Melanie, I don't think this prosecutor should be trying trials that have to deal with abuse. Thank you and your mods for keeping it very classy. Thank you. The mods do work very, very hard. We're just on a break. The court's coming back. They just went upstairs to look for some papers. Mrs. Michelle O'Hare, thanks to 5. Yes, I'm an RN and daughter's a paramedic. No freaking way EMS caused that contusion, and shame on the prosecution to suggest that. Dragging him and smacking his head into the door jamb. Thanks, David Reese. EMTs wouldn't drag someone out by their feet. Pilgrim Shadow, good morning. Thanks for the 20 and the Grateful Dead quote. He's gone and nothing's going to bring him back. He was an abuser, and I'm glad he can't hurt Ashley anymore. Thanks, Moz, for your work here. And thanks, Pilgrim Shadow, for your generosity to this channel and daily Grateful Dead inspiration. Heart of Inspiration, thanks for the 10. I hope every defense attorney in their jurisdiction is listening to this trial and will use this to exclude DNA lab reports from here forward. Thank you for the 10. Jason, thanks for the 5. This lady needs a cupcake and to chill. She's so angry. We love cupcakes. Lisa, thanks for the 10. In the early 1980s, as a paralegal, I did research at University of Michigan Law School. I 100% know what you mean. Put in new pocket parts, too. Love your coverage. Oh, remember those pocket parts that used to come in the mail? You have to assemble them into the back of all of the sub-seconds. Remember that, Lisa? Oh my gosh, we're dating ourselves now, right? Acquiring minds. Sorry, DNA is no longer confusing. Confusing? It's very, very interesting. And look at Tina popping in from Norway, or Teen. Hello from Norway. Love your stream. And interesting to follow the American system. In Norway, we don't have jurors anymore. Only 2 lay judges with the judge. That's interesting. So it's like a panel of 3 judges, no juries. That's interesting. I don't know what they're going to discuss when they come back, but maybe jury instructions? Please hit the like button. It's really, really great for the stream. Pocket parts. Yes, pocket parts. So true. See if I have any questions over here on this device. Oh, thanks for buying me matcha latte, to the anonymous person. And Terry bought me 5 matcha lattes and says, thanks to you and the mods, you're amazing. At Sydney Collins sent a Venmo and says, I love your coverage so much. Thanks for your humanizing defendants, your legal expertise and attention to detail. Oh, you also remind me of my best friend from college, which makes me love you even more. So glad I found you. Oh, thank you, Sydney Collins. You're so very welcome. Marianne, thank you for the Venmo. Very much appreciated. Christina, thank you very much for the Venmo. Wine Cellar Infused bought me a matcha latte and says, just because you work so hard for all of us here, thank you so very much. We got a severe weather alert at 2:46 that I'm just seeing now, which explained those crazy thunderstorms that we had earlier. Our North Coast sent an email that says, Luke and Michael Haig were supposed to be witnesses for the prosecution in the Rust case before Carrie Morrissey destroyed it. Thanks for clearing that up. That is pretty awesome. OFD bought me 5 matcha lattes for Ashley. Thank you so very much. Leslie, thank you for the matcha latte. You guys are so awesome. Colleen for the Venmo, says that I continue to educate her. Thank you so very, very much. Appreciate you so. And CHF. Nina, thank you. Thank you, Nina. I just looked at it quickly. Mr. Taylor is a very seasoned attorney. Even I know you can't bring in DNA reports through a detective. He should have called the lab for this guy. He had a case that said that it could come in as under the business records exception. And he is willing to call in the lab guy, but the lab guy can't come in for whatever reason, unless it's by Zoom tomorrow. And under the new rule, Florida Rule of Criminal Procedure Rule 3.116, they can't do Zoom testimony unless the other side agrees. Seems. If all parties consent. However, Maybe he's ruling that they didn't move ahead of time. They didn't make the motion ahead of time. That's what it seems. That's what it seems to me. All right, it is 4:43 p.m. I'm going to say we wrap at this point. I can recap for you in the morning, whatever it is that they discuss after they come back, but who knows how long they're going to be here tonight, and I'm sure that you all have things to do, as do I. So let us reconvene tomorrow morning, and I'll recap whatever happens here. I don't think we're going to miss a whole hell of a lot. But it seems that the defense didn't officially rest, right? Yeah, they should have planned a little bit in advance on that. Having the guy available. I agree with you, Scott McGinnis. Off topic, Christina Rex just posted the same juror she spoke to before the juror contacted the Commonwealth and defense. They have only heard back from the defense. Karen Reed?
This is the,
No, they're back now, so let's just see.
I gave it to them, and this is the standard. I don't know if you need that, but I brought an extra copy. Okay, this is the state's proposed. If you have already a copy of ours, you can toss it because I made corrections.
See, everything you can learn over here. So many things.
And as we get started again, I was able to find the jury instructions the defense had handed up to me in the past, and I've had my judicial assistant run a copy and gave them back to the defense.
All right, friends, we're going to wrap for the day. I'll recap this tomorrow morning for you. If you want to keep watching, go on over and brave yourself wherever you think you might be able to survive. And just, you'll appreciate me that much more tomorrow. And my moderators, thank you to all my moderators. Thank them, please. They work so very hard to keep this a classy place for all of you. And to my channel members, thanks for liking me enough to want to be part of my channel. Viewers, replay viewers, please hit the like button on your way out. It really, really helps the algorithm. The National TV hotline number, once again, is 1-800-799-7233. Please reach out if you are in fear or you need help getting out of your situation. And remember, my friends, just be cool, be kind, be classy. It's not hard, really. It is so not hard. Thanks again. I'll see you tomorrow. Peace out. Crazy day once again. Good night, everyone.